the previous course on feminist legal and political theories. But there I was more sort of a guest the course of Professor Dragica Vujadinovic. Today we are starting with the Human Rights Gender Perspective course. Tomorrow we're going to have Feminist Judgments, the beginning of that course. So we're going to be working in the next 3-4 weeks rather intensively, not just with me, of course. This course, Human Rights Gender Perspective, is taught by Professor Ivana Krstic, Vojna Čutković, and myself. And the course which is going to start tomorrow, the Feminist Judgment, is taught by Professor Ivana Krstic, Maja Lukić, Radović, and again myself. So we're going to be having some time together in these next 3-4 weeks. And I would like to actually also, apart from presenting myself, hear also a few words about you and of course your names and surnames and what is your background and what are your interests in taking this this master program. What were the reasons for taking it? So just very briefly, I would like to say that I'm very much happy and pleased that we have you this year and that we are able to deliver this master program in full terms as lectures. This is a very quality program which we have been working hard on for a couple of years because this is the second generation of delivery of the master program, but previously we had various summer schools. And also we had very intensive international cooperation in order to establish it. This master program is a part of Law and Gender Erasmus Mundus project. So it was partially made through Erasmus Mundus projects. And also I'm very happy to tell you that we're going to start delivering relatively soon another type of master which is related to these issues of law and gender, although this master is called has an intersectionality in its title. It's called Logit, and it's going to be a joint master which we're going to deliver together with Örebro University from Sweden and Palermo and Lunds University from Palermo. So these three faculties, universities have applied, and we got the grant from the European Commission for the joint master's program. It's a type of a program which means that students will have a diploma of these three faculties. Right now, those who graduate from our master program will have a degree from Faculty of Law, University of Belgrade, and those who will enroll into that other master will have a joint master degree. So this is also, in a way, a proof of our motivation and of our dedication to this topic, and also a proof of the quality, since it was very hard to get this financing funding from the European Commission. My name is Tanasije Marinković, and I'm actually a professor of constitutional law and human rights law at the Faculty of Law, University of Belgrade. I've also been teaching European Union law a bit, and I've been teaching a lot human rights law, and so in that context, I also I'm very much motivated and invested in this issue of gender equality. Now, this will be exactly the issue that we will be dealing today. Within this course on human rights gender perspective, we will take a look at to what extent human rights is itself invested with gender equality, to what extent we can say that there is gender equality in human rights. And it may look as a very weird question because we consider human rights to be somehow at the apex of the legal system, at the top of the legal system, to be themselves the most modern part, most developed, most progressive part of a legal system. Yet we will see that human rights law or sometimes we call this branch of rights basic rights, are not always invested with gender equality, and that gender equality is not taken seriously even within the context of human rights. So this is the issue that we will be dealing today, where we started from when it comes to the idea of equality and freedom for everyone, a universal concept. When we take a look at how these concepts started being developed already in the ancient period, in the works of ancient Greek and Roman Stoics, and that even though there is a very long history of human rights, of basic rights, from natural law to modern basic rights, that the gender perspective was not always taken into account and is still not sufficiently taken into account. So this will be some of the topics that we will address today. We have 2 students here in the room and much many more online. This is the consequence of the fact that we allow for the online participation, and of course it is very much justified in certain circumstances, but I encourage you, all those who can come, to be present in the room here when we deliver this course and when we deliver other courses, because it's the interaction is also something that we insist on. Interaction is also a way of ethics of care, which is in itself a part of the feminist tradition, because interaction presupposes that we take each other seriously and we don't just do a lecturing in a one-flow way. There is always 2-directional way of teaching and learning. So in that sense, I understand that some of you couldn't come and be present, but at least you can open your videos so that we can see you. This way, I really feel uncomfortable having so many boxes with names and without faces. It's not very nice. Thank you. Okay, so I insist that you all open your cameras if you did not understand me. Okay, now for the students who are in the room, could you just present yourself and say a few words about yourself?
My name is Marlon. I'm not really in this master's because I'm an Erasmus student from Germany, in Hamburg. And I just picked some courses that I'm really interested in. And for example, like feminism, gender, an interest of mine. And for me, it's in Germany, especially, I think in other law schools too, we don't really have this topic in our when we take our effort. So for me, it was really good to also get a different view on law and from women's perspective. So yeah.
Thank you so much. Just remind me once again your name. Myla. Yes. Thank you, Myla. This is a very the topic of gender equality is very it's not new, but teaching it to the law faculties is relatively new. Especially having full courses on it or full master programs. So that's relatively new. And this is, of course, one of the reasons, as I said, why it was recognized by the quality of this program was recognized by the European Commission. Also, we could say that in the past 10, 15 years, this issue has been gaining in importance and in recognition. And now I fear with the latest developments on the international scene, and with the general backsliding of democracy and rule of law in various well-established democracies, not just new democracies, that this will affect as well the status of these kind of projects and schemes, in terms that there will be less and less support, financial support for these kind of schemes, these kind of programs. And we will see how much gender equality will be in itself respected as a value, as a principle, and as a right. we have also seen some regression in the case law of the Supreme Court of United States of America. In this respect, in Europe so far, I have to say that when it comes to those supranational courts, such as European Court of Human Rights and Court of Justice of the European Union, we stand relatively well, yet without any changes in this respect. So we can be happy about the situation in Europe, but when it comes to this issue on a regional level, on a European level, but when it comes to individual countries in Europe as well and across the world, I'm afraid that we may see a period of regression of gender equality related rights. Okay, Myla, yeah? Thank you, Myla.
My name is Lucia, and I haven't said it, but I'm the reference student too. And it's currently discussed it's not in the country. I'm from Russia, and it's very close topic for us, and it's very interesting to see your view.
Good. Thank you so much for being with us. Since you're on a different type of program, you can also apply for this logic once we start delivering the course, because it's not going to be in this year, 2026, 2027. It's going to be as of 2027, 2028. So this joint master's program. Okay, and so I see here Alexander Lisulov. Alexander, do you want to say a few words about yourself?
Of course. Hello, Professor. Hello, everyone. It's nice to see you all again. We've actually met already, Professor. You oversaw my constitutional law exam when I was a student at the Faculty of Law. It was a long time ago, so you probably don't remember, but it's still nice to see you again. The reason I applied for this master's is because this is a topic I'm very interested in. I generally follow politics, philosophy, and I just find it an interesting and intriguing topic. And it's been fun so far. I think I've learned a lot and expanded certain areas of knowledge I already knew things in, and I look forward to learning more and to working with everyone here.
Thank you, Alexander. And where do you come from? From which university?
From Belgrade. I live here.
Okay.
Lived here all my life.
Okay, and law faculty, yes, you said yourself.
Yes, I'm a student at the Faculty of Law.
Good. And Myla, Anastasia, you come from which faculties? Are you from law faculties or? Okay, because you also enroll students from other social sciences. We also have students from political sciences, from Faculty of Philology, other faculties as well. Abdi Habeb, are you here? Do you see us? Do you hear us?
Yes, sir.
We don't hear you, Abdi, and if you can open your camera.
Well, my internet was bad, so
the internet is bad. Okay, so maybe this is the reason why you have closed your camera. I hope you can at least hear us.
Yeah, I hear you, but my internet connection was bad. So give me a minute.
Okay, no worries. When I hope it's going to be soon, but whenever you're available, you can connect. I mean, you can anyway. This is the rule with my classes. You can always interrupt me, ask question, and raise the issue, comment, and so on and so forth. So anyway, these are we try to develop and insist on interactivity as much as possible. Ksenia.
Hi, everyone. I hope you can hear me well.
Yes, we can hear you.
My name is Ksenia Petrovic. I have graduated from University of Belgrade Faculty of Law in 2019. And I never thought that I would enroll in any master's program. It was not in my plans at all. Valuable knowledge to implement it in real life, in situations that I saw multiple times in companies and offices, which is the reason why I'm here.
Okay, great, Ksenia. I'm very happy that we have you on
you.
board, and we hope that you will be up to your expectations. And
Thank
don't
you so
hesitate
much.
to ask from us as much as you can within the limits of our competencies and legal obligations, of course.
Thank you so much.
You're welcome. Saiful Islam Muzmade, Mozumade, yeah?
Yeah.
François?
Can you hear me?
Yes, we can hear you.
This is Saiful Islam Majumdar. I am from Bangladesh.
Mm-hmm. Nice to meet you.
My graduation, Department of Finance and Banking, University of Rajshahi, Bangladesh, and completed my masters also from University of Chicago, Faculty of Economics.
Mm-hmm.
I am now at Chicago in subject is Public Financial Management.
Very good.
Now I study law and gender. I am very much interested to this field, and I am trying to shifting to Belgrade. I may be trying for a job here in Belgrade. If I go to get a job here, Belgrade, then I ship it from Chicago back to Belgrade immediately. And I think in the next month I can be in the class physically. Hope so.
Okay, that will be really great. We are looking forward to welcoming you here in Belgrade in person. Okay, and also just like for everyone else, you don't hesitate to ask questions and to intervene whenever you feel like, whenever you feel like there is a need for some additional explanations or inputs. Dušanka Tomašević.
Hello. We met on the feminist political theories. I have a bachelor in political science, in international relations, and I work as advocacy program coordinator at Labris, that's a lesbian human rights organization. We are currently leading a strategic litigation for same-sex unions, same-sex marriages to be precise. So that's kind of when I really got interested in law and the whole practice. And yeah, so that's about it.
Great, Dušanka. I hope that we will be also up to your expectations and your need professional at this moment, of course. Jelena Stubic.
Hello, I'm sorry for not turning on my camera. I have a flu and I'm not representative at the moment, but I will probably come to the class tomorrow. We already met on Professor Dragica lecture. I have a law background and I'm currently working at OSCE mission to Serbia. And I'm working on parliamentary support program, and actually working on a lot of stuff related to the gender topics, such as adopting the gender action plan in National Assembly. And so that's like right now the connection between the master and my work. But previously in my work, I have also been working on the gender topics, and it has been in my interest since actually high school. So yeah.
Wonderful. It seems like a very substantial connection between what you're doing right now and the topics that we are dealing with in this course. And I also hope that we will be up to your expectations, Jelena. And Una Danilovic.
Yes, I hope you can hear me. I also have the flu and I'm coming back from the doctors right now. So I graduated at the Law Faculty University of Union. And now I'm currently working at Lawyers Committee for Human Rights. So that is how this course especially is connected to my work. We do a lot of work, not just broadly about human rights, but also gender issues. So I'm very excited to deepen my knowledge from this course.
Great, Una. I also see that you have a very substantial connection with these topics. And once again, just like for everyone else, don't hesitate to profit from the course as much as you can, also by asking questions and also participating in the class or and in all other ways of activities and forms of activities that we offer you in this master program. Now, let me start with the presentation, because we have already, I was almost half an hour late with the beginning of the course. So, do you see the presentation, you who are online?
Yes, we can see it.
Yes, we can see everything.
Okay, that's the biggest stress of the beginning of every course. That is whether the online system is going to work. So, as I said, this is a course which is dedicated to the. Just trying to do something else as well. Okay, now it's better. Okay. So our topic is, I mean, the whole course is about human rights and gender perspective. As you will see throughout this course, we will be studying different concrete human rights from the gender perspective. Okay, so this is the idea of the course, to enable you to understand what is the specificity of human rights in the context of gender equality. And what is it new that gender equality brings to human rights? Now, the issue may be at first glance bewildering. We may ask ourselves, what is the problem? Isn't the human rights, as I said already, isn't that the most progressive part of any legal system? Especially if we speak of European legal systems, and especially if we speak of the European Convention on Human Rights, so the case law of the European Court of Human Rights, if we speak of the case law of the Court of Justice of the European Union, or if we speak of the CEDAW Convention, 1979 CEDAW Convention, so the Convention on gender equality, so the UN Convention. So the question may be, what is the issue? Isn't that presupposed? Isn't it self-understood that human rights includes in itself a gender perspective, and that women, just like any other humans, are granted the same rights as everyone else under the general rules of the UN, or as international, as a global worldwide document, or under any regional document granting human rights. Well, that is not quite the case, and there is actually, unfortunately, a very long history of disregard of women in law, and of subjection of women, not only in practice, not only de facto, but also in law de jure. So what is interesting to look at, for example, is the Declaration of Rights of Man, the French Declaration of Rights of Man of 1789, considered as one of the most progressive, and definitely the most progressive document on human rights in that period, Declaration of Rights of Man. But as you can see, this is how it is entitled, Declaration of Rights of Man. So it was clearly understood, it is called Déclaration des droits de l'homme. So there is no doubt that this is about men and not about women. And that it was clear, although there are some linguists and some theorists who would say that when we say man, even in English it doesn't seem credible. In French, it doesn't seem credible either. When we say l'homme, we mean man. Persons of masculine sex, and we don't mean women, femme. Just to confirm that this was the idea, this was the understanding of these terms already in the late 18th century, we can quote Olympia de Gouges, so a French intellectual, a writer, a philosopher as well. She wrote a declaration of rights of women, exactly because at that time women were not allowed the same rights as men. And that was in 1791, just 2 years after the Declaration of Rights of Man. So just to show that at that time, there was no understanding of women as category of law, as persons who would be entitled to the same rights as men. And not only that was the case end of the 18th century, but as we can see from this quote of Belgian constitutionalist Oscar Oldboom from the early 20th century, he says in his textbook on the Belgian constitutional law, he says, not only that constitutional equality does not prevent, but it commands the respect of the distinctions resulting from the nature of the things, life and social realities, such as the sex. So the distinction between the sexual distinction between men and women was used as an argument to disadvantage the women throughout history. And this is a statement from the early 20th century. So, and you can imagine that earlier in history, the situation was even worse when it comes to position of men and women. So, not without much surprise, one of the major radical feminists in the second half of the 20th century and first half of the 21st century, Catherine McKinnon, wrote a book asking the question, are women human? So if women are human, what we understood linguistically, as we understood the term human linguistically, and as we understand it as it is generally understood in any social and natural science, if women are human, why are not they allowed the same rights as men? And just to again show how these things are serious, in 2011 we adopted in Europe, so I was already mentioning Europe as a place where we can say that there is the most developed system of human rights across the world, across the globe. So this is definitely the case with the European Convention on Human Rights and European System of Human Rights Protection under the jurisdiction of the European Court of Human Rights in Strasbourg. And nevertheless, even in Europe, within the Council of Europe, so those countries, 46 countries of Europe, unfortunately, Russia was expelled from it, and Belarus was never applied, never became a member. So all other European countries, from Iceland to Georgia and Caucasus republics, from Finland to Portugal, all other European countries are part of it. And yet within the Council of Europe, as that regional organization, which is the most progressive in the protection of human rights, we needed to adopt in 2011 a convention on preventing and combating violence against women. So this just shows how things are serious and how far we are, not just in reality, in the protection of women and granting them the same rights as men do enjoy them, but also that in law we still haven't always achieved that kind of equality. And this is why we have decided to introduce this course on gender perspective in human rights, on the need to emphasize and to address the issue of gender equality in human rights, yeah, let alone other segments of law. This is what I was saying was just a sort of paraphrasing of the words of Catherine McKinnon, who said, if we measure the reality of women's situation in all its variety against the guarantees of the Universal Declaration, not only do women not have the rights it guarantees, so here she speaks of the Universal Declaration, 1948 Universal Declaration, United Nations Universal Declaration on Human Rights. So it's Universal Declaration on Human Rights. But it is hard to see, I come back to Catherine McKinnon, it is hard, she says, not only do women have the rights it guarantees, most of the world's men do not either. Well, that is also true, that we have to admit that in many parts of the world, Universal Declaration is not respected, even for men, and in that sense, even less for women. But it is hard to see, says Catherine McKinnon, in its vision of humanity, a woman's face. Women need full human status in social reality. So this is what Catherine McKinnon takes as a sort of a torch. You know, she wants to. This is the kind of a battle that she wants to lead, and this is also, if you want, the position of the European Court of Human Rights. We are interested when it comes to human rights in general, and of course, women's rights, gender perspective. We are interested into how much these rights are actually respected in practice. We are not interested so much what is said in letters, what is said in law. It is good to have good laws, but we are not going to be happy with just adopting good laws. We want to see those laws being applied. Whether they're applied through substantive legislation, as it is typical for European continental countries, or when it comes to common law countries, whether these standards are developed through case law, through sort of legislation making through judiciaries and by judiciaries, that is irrelevant. What is important is that in practice, there is protection of human rights, and in this concrete case, of women's rights. And this is why she says it is hard to see in its vision of humanity a woman's face. Because, as we will see, for many, many centuries and millennia, law didn't recognize women and their particular needs. Not only that the law did not recognize particular needs of women, the law did not, so in other words, the law did not recognize that differences between men and women, physical and other differences, are actually a reason to readdress the needs of men in one way and the needs of women in another way. But, so not only that the law does not recognize these differences as values which should be cherished and protected and further supported without disadvantaging women or other cases of gender equality when it comes to transgender persons. So not only that we don't, that for a long period of history we did not recognize these differences as values, but we consider these differences to be the exact reasons for disadvantaging certain categories of population. And we will see exactly how the human rights law developed in that sense. This is what she says, what she means, Catherine McKinnon, by these words: women need full human status in social reality. We need to look into social reality and how much women have this human status in social reality. Yet we live nowadays. Okay, I mean, to be frank, Russia's aggression on Ukraine and also recent acts of the American president and the United States of America are seriously endangering the international system as it has been developed after the Second World War. This is why this slide is entitled "We Live in the Age of Rights." Because after the Second World War, we realized, or actually exactly due to the Second World War, we realized that there was a need for international protection of human rights, so as to try to prevent, if that is possible, from the international level, the respect and protection of human rights on the national level, just to react and to prevent the tragedies which occurred in the Second World War and post-Second World War, where a period where, as you know, there were totalitarian regimes which directly disregarded, disrespected human dignity. And so, exactly because we realized that the Second World War and sorry about my, just realized it doesn't fit properly. Exactly because we realized how things can get bad in the modern world at that time with new technologies of mass media, which were introduced in the between the two world wars, and which were massively used to manipulate people in the period between two world wars, especially in those totalitarian countries. And not only that, but to engage a military, which was much more technologically developed in the Second World War as compared to the First World War. And again, the 20th century military technology is by far, exceptionally more performant than that one in the 19th and the previous centuries. All that was a result of the development of sciences in the 19th century, positive, natural, and technical sciences. We realized that this development of natural and technical sciences, these new technologies, can be, of course, useful for humanity, but they could be also the collapse of the Berlin Wall, the demise of the Berlin Wall, so the end of the Cold War era, and what Samuel Huntington called the third wave of democratization, the new wave of democratization, which started with democratization of Portugal and Spain, and previously Greece in the 70s, and then also with the end of 80s and beginning of 90s of the previous century, the spread of the wave of democratization to Central and East European countries. And therefrom, this wave continued across the world into other regions. So we had this mutually stimulating trends of globalization and democratization, which meant that constitutional law, so the supreme law of every country, the constitutional law, was invested with international law standards. And that is particularly the case with human rights law. Because after the Second World War, as I said, we started establishing international and regional organizations for the protection of human rights, including, for example, the United Nations. So in the Charter of the United Nations, Article 55, it says, the United Nations shall promote universal respect for and observance of human rights and fundamental freedoms for all without distinction as to race, sex, language, or religion. So the United Nations were established with the purpose of furthering, improving these rights. And not just United Nations, but as I said, we have many international documents of human rights. including those directly related to women's rights, such as CEDAW, 1979 Universal United Nations Declaration on Equality of Women. And also we have, as I said, regional documents and regional organizations, primarily in Europe, the Council of Europe, but also in Latin America, but also in Africa, the regional documents and organizations established to further human rights. So there is this trend of internationalization of constitutional law, since in these international organizations, at that time, for decades, we tried to put our best lawyers. It was something new, and we, when I say we, I mean the humanity. Generally, all countries try to send their best lawyers into these committees which were drafting these documents, or into these committees and courts which were applying these documents. So we used to send, and we generally still do, most competent people into those bodies. And as a result, there is a very progressive branch of law which got developed in the meantime, which is international human rights law and European human rights law. This is why, as a result, the constitutional law, which was previously the most progressive part of law, of legal system, started being invested by these even more progressive elements. And on the other side, we realized that there was a need for the constitutionalization of international. That due to these developments, we needed to reinforce the bonds between the states on the regional and international level by introducing elements which, as I said, keep these organizations more together and stronger. This is what we call constitutionalization of international law, and of course it was more possible to do it on a regional level than on international level. And these elements of constitutionalization of international law are particularly present within the context of the European Union, which initially started as a coal and steel community, and it gradually developed from 1951 to nowadays. So we teach also at this faculty and across Europe as well the constitutional law of the European Union. So we do admit that there is a part of the European Union law which we can associate, identify as constitutional law, and also we can say that not just within the European Union, but also within the Council of Europe, which is a much broader organization, 27 in the European Union, 46 in Council of Europe, that even in the Council of Europe, we can speak of these constitutional law elements. And they're particularly present in through the jurisdiction of the European Court of Human Rights in Strasbourg. Because thanks to this court, thanks to its case law, and thanks to a dialogue between the national courts, primarily the Supreme Courts and constitutional courts in member states and the European Court of Human Rights, there is a consideration, understanding that the judgments of the European Court of Human Rights are mandatory, and that legal systems, national legal systems, in all councils, in all 46 countries, have to adopt and have to actually apply that case law of the European Court of Human Rights. And that case law affects not just the judgments of Supreme and the Constitutional Court, but it also affects the legislation of the member states. And we will speak more. I won't go now into these details. If there are questions, if there is a need, I will of course answer those questions. But this is just to show the world, what is the world like nowadays. I have to also warn you that due to these terrible facts, terrible acts which took place in Europe and in the world in the past just couple of years, the fact that Russia was expelled from the Council of Europe, it's a very big blow for the Council of Europe as well. It's very detrimental for the multilateralism on the European level. It is also a sign of incapacities of these organizations. And we can even more speak of the incapacity of the United Nations nowadays to respond to its initial mission and its initial functions. And this comes not just as a result of the incapacity of these organizations, but comes as a fact of the decision of these states, of these major states, these states which were the part of these systems, or which are still part of the systems when it comes to United Nations, not to respect it and not to actually promote in its work, in its practice, multilateralism, but rather to undermine it. So we were all born in the so-called post-Westphalian world after the Second World War. Everything that I just described, all these developments, are a sign of a new international order which was gradually built. And that is a type of order which directly contrasts with the so-called Westphalian world order, which was created after the Westphal Peace Treaty of 1648, when it was generally recognized on the international level that states are sovereigns and that they can do in its mutual relationships whatever they wanted. So that in that sense, there was no prohibition of use of violence in international relations. And the war was not forbidden in terms of international law. Whereas with exactly United Nations Charter and post-1945 developments, we introduced a new type of, we started introducing gradually a new type of world order called the post-Westphalian, which implied certain limitations on the member states. Well, these past couple of years, we are unfortunately witnessing the degradation of this post-Westphalian world and potential return to or revival of something that we could call neo-Westphalian world. So we can say that we are to a certain extent, there is a risk of returning to the Westphalian world order. Okay, so this was a little bit, this was a small excursion into international law because, of course, of the importance, and you have also a course on international law and gender equality. So in that sense, this was useful just to understand why we make so much references to these international and regional documents. Yet the intellectual origins of the rights revolution go back quite a way. So when we look into history, we can see that the humanity developed for many, many centuries without respecting the rights of men and even less rights of women. However, the entry of human rights or rights of men into the world scene is related to the late 18th century. So here there is a passage from Declaration of Independence, United States Declaration of Independence of 1776, by which the North American colonies started their liberation against the British Empire. So in the Declaration of Independence, it is stated, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of people to alter it or to abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness." So, when we speak of the age of human rights, and when we speak of the human rights revolution or human rights revolutions, we refer to these democratic revolutions of the late 18th century, which placed people in the center of the political scene. These are, for this reason, we call them democratic revolutions, and we also relate to this revolution as human rights revolutions, because human rights were introduced as a concept, not just in philosophy, not just in philosophy of enlightenment, we'll see, not just in the natural law, but they became a positive concept, because here, this is a document which is also considered as a positive law document in the context of the United States. And there is also, soon after this declaration was adopted, the Constitution was adopted, the first 10 amendments to the Constitution were adopted, 12 amendments. So in that sense, in the United States and then in France, through the Declaration of Rights of Man and Citizen, the human rights concept as a positive law concept was introduced in these countries. So it was not just a mere philosophy, not just natural law, but it was a positive law concept. Here we see that this positive law concept draws its origins from the naturalist tradition, and that is one, so to say, one strand of the development of human rights law through the philosophy of natural law. We won't have time to go into all the shades and all the stages of development of natural law. As I said, from the ancient Greek and Roman Stoics through the Christian and the Catholic Church natural law, and then coming to the modern natural law with Hobbesian, Lockean, Rousseauist political and legal theory. What is important is to see that this natural law tradition has very much inspired these first documents on human rights. So this what we speak here, what we see is a recognition of human rights as fundamental rights, setting the basis of the legal order. Yeah. So this is what is meant when we say that these rights are inalienable, and that among them there is right to life, to liberty, and to pursuit of happiness. We see that these human rights are recognized. They started being recognized through legislative documents, such as these late 18th century declarations, and also they are also adopted, depending, as I said previously, on the type of the legal system. They're also introduced in the legal system potentially through the case law. In the common law countries, there is case law. The courts, they also develop law. We call this judicial lawmaking, and we will talk more about the importance of judicial lawmaking in the tomorrow's course on feminist judgments. What is important to retain at this stage is that naturalist tradition implies that these rights should be introduced in the positive law, and in that sense that there is a substantial hierarchy of these rights over all other rights, and that this substantial hierarchy prevails over the formal hierarchy. Meaning that if legislative and jurisprudential acts do not recognize human rights, well, then there is a right to resistance, jus resistendi. And we have this right to resistance recognized here in the Declaration on Independence. We have it in the Declaration of Rights of Man and Citizen, and we have it in German basic law, in the German Constitution. Basic law also provides right to resistance, exactly as a reaction to the previous regimes. Here, the Declaration of Independence basically makes reference to the bad government, malgovernment of the British Empire. When it comes to Declaration of Rights of Man and Citizen, right to resistance is a reaction to the ancien regime and to the previous malfunctionings of the France in the especially in the throughout the 18th century. And the German basic law introduces right to resistance as a reaction to the atrocities of the Nazi regime. So we have we can see this causal relationship between some let's say malfunctionings, malmanagements, or even atrocities, and as a reaction to it, demands for more rights deriving their legitimacy, their authority from the nature of the things. This is the naturalist tradition in the ancient period, or from the will of God in the Christian form of it, or from the recta ratio, from the right reason, considering that this is the most reasonable thing that one can expect and one can assume. And this is one strand of human rights and one source of tradition of human rights. The other strand or other tradition is the positivist tradition, but I will now, if you allow me, make a short break because it's been almost 1 hour, and we'll have just one break in order to catch up. So we will continue in 10 minutes in order to catch up for the loss of those first 20 minutes of the delay in the beginning of the course. Okay?
It's okay.
So see you in 10 minutes.
Okay.
বলো ক্লাসের ব্রেকে আসি বলো
যখন কল দিছিলাম ওই নাফিস জানেন আব্বু নাফিস কি বলে একটুক্ষণ পর এসে বলতেছে যে নোয়া গাড়ি বিক্রি করে দিতে বলো তোমার স্বর্ণ দাও ধরো কালকে বসুন্ধরা যাবে স্বর্ণ কি এসব বলতেছে মায়ের পুরো যে সারা রাত ভাত খায় নাই বলে 21 দিন ভাত খাবে না চ্যাটজিপিটিতে সার্চ দিছে কতদিন মানুষ ভাত না খেলে মারা যাবে এগুলি করে বেড়াচ্ছে মানে কাহিনী আছে বলছে এতদিন মোবাইল চালাম মোবাইল দিল না এখন মোটরসাইকেল আছে কোনো আমি কই মোটরসাইকেল দিব
দিব তো বলছি ইউনিভার্সিটি ভর্তি হোক দিব তো না করে নাই এখন কারণ মোটরসাইকেল চালাইতে গেলে 21 বছর বয়স না হলে আইনগত চালাতে পারে না নিয়ম নাই
মানে একটা ফোন টোনের একটু ব্যবস্থা করে দিতে
ইউনিভার্সিটিতে ভর্তি হোক তারপর
একটা ফোন দিয়ে আশাটা রাখি
আমার এখন কথাটা বেশি কবা না কথা হলো আমি এখন বিপদে আছি টাকা দিচ্ছি বলে মনে করো না যে আমি টাকার ভার বানায় ফেলাইছি যেটা দিচ্ছি এটা হলো প্রয়োজন এখন প্রয়োজন হুন্ডা ওরা কিনে দেবো আমি না তো করি নাই কিন্তু হুন্ডা প্রবলেম আছে তোমার কথা বোঝার চেষ্টা করো টাকা আমার কাছে আয় কিনছে কি না এটা কোনো বিষয় না ওরে বলো ওর কাকারে ম্যানেজ করতে হুন্ডা কিনলে আমারে বলে লাভ আছে কাকারে টাকা তো আমি দিই শরীফ দিয়ে প্রশ্ন না ওর কাকার সাথে কথা বলতে বলো যে কাকা যদি রাজি হয় হুন্ডা দেখি তাহলে আমি কিনে দেখি আমি কি ভেজালে বলবো নাকি কথাটা বুঝো নাই তুমি তো বুঝো না ব্যাপারটা এখানে ওরে বল ওর কাকায় ম্যানেজ করে কাকার হ্যাঁ দরকার থাকা থেকে নাই এটা বড় কথা না ও যদি কাকায় ম্যানেজ করে কিনতে পারে কিনুক আমার কোনো ইস্যু নাই আর পার্সোনালি আমি হুন্ডা পছন্দ করি না কারণ খুব রিস্কি যান অল্পতে মানুষ ক্ষতিগ্রস্ত হয়
আর এখন হুন্ডা বানানোর বয়স হয়নি লাইসেন্স করতে হবে ওটা দরকার নেই
ঠিক আছে
পারলে মোবাইল একটা দিলেও
বাদ দাও মোবাইল পরে দেখা যাবে এখন কি খবর আগে পরীক্ষা দিতে পাস করতে গাও সব হবে সমস্যা নাই
আচ্ছা ঠিক আছে
তোমার কালকে ভর্তি করায় ফেলাও তারপর তো হয়ে গেল আর সবকিছু এই আর কি
ঠিক আছে
আল্লাহ ভরসা আর মাসে মাসে বেতন দিয়ে দিবে বেতন জমাইবা না
হ্যাঁ এবার তো ওটাই মনে করছি যে একজনের দিলে আরেকজনের না পারলেও এভাবে চলমান থাকতে হবে
ঠিক আছে
এবার সব দিলে ঠিক আছে
Oh, Dobro Bache, it's a problem for me. I on client class, my head is problem. It's not okay. I give me one bed, not two bed. Give me one bed, not this. You shifted from here. আমার সমস্যা হয় না। It's a cold. Jima. This bed, Jima. Jima. It's good. Shift this. This bed is so cold. The upper bed is so cold due to window. This is so cold for window. Prozor, due to prozor. Cold. I need one bed, single bed.
Sleeping too.
No, single bed, not this one. Like one single bed. They like this one single bed. Not you take this from other room. Sutra, no problem. Change. Not yeah.
Okay. Sutra, okay.
Sutra.
Okay. The sutra tea work.
Work, yeah.
Okay.
Okay, we continue. Do you maybe have questions or comments about anything that I said or? Okay, good. And you who are online, I mean, if you have questions or comments, I suggest that you just take the floor because I can't see you all due to the system as it is. So if you would like to take the floor, you can do it. Anyway, as I said, you can interrupt me while I'm teaching as well. That's perfectly fine by me. Okay, if there are no questions or comments, I will continue. Anyway, unfortunately, our time is limited. So I started explaining these two traditions of human rights in order to understand what do we mean by human rights. Because so far we haven't defined human rights. And we are supposed to teach in this course about the gender perspective in human rights. I did say that human rights are expected to be the most progressive, most modern part of a legal system, a sort of a crown of a legal system. Yeah? But in what sense, why and how, this I haven't said at all. So there are these two traditions of understanding human rights, and they are to some extent divergent, different, opposing, but also we can recognize periods and situations in which these two doctrines or these two traditions overlap and are actually mutually supporting. The other tradition is the positivist tradition. Okay, so there's the naturalist tradition and there's a positivist tradition. The positivist tradition comes from generally the influence of positivism as a philosophical movement, as a scientific movement in 19th century, as its influence on law, and on our understanding that law is only a system of sources, of norms that we can objectively recognize and that we can, which really exist, which are at place, and not just as a natural law somewhere in the nature, in the God's will, in someone's understanding of what is the recta ratio or the right reason. Hence, these two, as I said, these two traditions. And according to the positivist tradition, And I call upon you to really take a good look at this slide and at this definition, because this is actually a proper definition of human rights. I say this because there is also there are also those political movements, and also there are those lawyers who demean the human rights and who consider, irrespective whether we speak of gender perspective or not, who think that human rights are just actually something which is an object of manipulation, an instrument of manipulation, and that human rights are used as a tool in the hands of big powers to interfere in the lives of small nations or within the nations, that human rights are something which is manipulable in itself because they're so vague, so undefined, so difficult to recognize, exactly because one strand and one tradition of human rights is natural. So what is considered as nature is a matter of discussion, of course. However, when we look at the positivist tradition of human rights, we can see that human rights are actually something which is very definable and very concrete, and that it is not so easy to manipulate. In that sense, what we understand by human rights are norms in the strict meaning of that word. So, permissions, freedoms, entitlements, which are addressed to everyone. So, human rights, by definition, are enjoyed by everyone. They're addressed to everyone. Or at least to a general classes of addressees. Not to everyone, but to certain classes of addressees, such as women, such as children, such as racial minorities, religious minorities, ethnic minorities. So human rights are permissions, freedoms, and entitlements, which are addressed to everyone. So everyone, in principle, everyone is considered as a beneficiary of human rights, regardless of the citizenship. Regardless of the citizenship. Under the international and European standards of human rights, you cannot inflict violence upon anyone. Okay? So even less you can take someone's life. Whether that person is a citizen or not a citizen, it is irrelevant, for example. Only in certain situations we consider that certain human rights are related to citizenship because of their very nature, such as political rights. But we'll come to that. We'll come to that point. Secondly, human rights are only those permissions, freedoms, and entitlements which are of supra-legislative level. So they have to be enshrined in the Constitution or in the international treaties. Legislative or infra-legislative norms contradicting the human rights norms are considered as invalid. So there is a formal hierarchy of norms. There has to be, as a consequence, a judiciary empowered to annul the invalid norms. These are all elements of the standard of human rights. If you don't have courts, and of course, these courts need to be effective, efficient in the protection of human rights, not just the courts on the paper. You don't have human rights in the legal system. So, there has to be a system of entitlements, permissions, freedoms on one side. There has to be granting the which are addressed to everyone or to certain classes of citizens, of addressees, not necessarily citizens. They have to be of supra-legislative, so constitutional or international level. There has to be judiciary, meaning constitutional courts, Supreme Courts. It can be the whole judiciary, depending on the type of the judicial review of constitutionality, which is in place. And there have to be international courts or other bodies such as committees like Human Rights Committee or committee under the CEDAW Convention. The applicants entitled to bring an action before the judiciary to invoke human rights violation. So not only that there should be beneficiaries, there should be holders of rights. So these are two different categories. Holder of rights implies that I can protect my life, my right. It means that I have an instrument through which I can bring my case before this and that court. For example, a constitutional appeal that we would have, or Verfassungsbeschwerde in the German legal system, or constitutional appeal or complaint in other legal systems, or a possibility to bring a case, an application before the European Court of Human Rights. If there are formalistic impediments to the possibility of an individual to bring a case, his or her case, before a court, so there is no actually access to the court, we cannot say that there are human rights in that legal system. These are all the elements of the positivist tradition of human rights. These four elements are considered as an inevitable part of the definition of human rights. It's not just a declaration of rights and freedoms. It's not just a declaration of goodwill. There has to be a judicial system set to protect it. There has to be instruments for individuals to bring the cases. There has to be a possibility to invalidate the norms of that legal system if they are if legislative or infra-legislative norms, if they are in contradiction with these rights. And there are different names, labels, ways of defining these rights. Historically, as I said, we spoke of rights of man. Then historically came the concept of human rights. There is a concept also in the human rights as a concept is Anglo-Saxon. Rights of man as well, or droit de l'homme, the French version, also applies. Human rights as such are considered as a term which is imbued, inspired by naturalist tradition. Because we consider the Universal Declaration of Human Rights, 1948 United Nations Universal Declaration, to be a sort of charter for the whole world when it comes to human rights. Declaration for the whole world, embodying, symbolizing common values of the whole world. And we consider that that Universal Declaration is binding as an international document upon all member states of the United Nations. That it received a sort of a customary binding force. It's considered that it has received a customary binding force. Public liberties is a French term, liberté publique, which is positivist in its tradition, but related to those rights which are guaranteed by the French laws, because the French Constitution, 1951, doesn't have a charter of fundamental rights. and and it was through a decision of the French Constitutional Council in 1971 that the Declaration of Rights of Man and Citizen became a positive part of the French constitutional law, what they call the bloc de constitutionnalité. So it was a decision of the French Constitutional Court in 1971 to give to that declaration a binding force, just like a famous 1803 Marbury versus Madison ruling of the United States Supreme Court gave to the Constitution of the United States a binding force when the court decided at that time not to apply the law which it considered to be in contradiction with the United States Constitution. So a similar kind of, so to say, revolutionary judgment was rendered by the French Constitutional Council in 1971 when it gave to the French Declaration of Rights of Man and Citizen this binding force when it's included in the bloc de constitutionnalité. Before that, in French law, since there were no rights in the constitution, the only rights were in the laws, and this is why we spoke of the liberté publique. And in German tradition, Grundrechte, fundamental rights, is a concept which is actually considered as fully fledged positivist. Yeah? So, and to a great extent, due to the relatively rich charter of fundamental rights in the Constitutional Court. For most of the natural lawyers, as I said, or supporters of the naturalist tradition, we saw the recognition of those rights which are considered as natural rights. We saw the recognition of those rights in the international treaties and in the most progressive constitutions. So in that sense, we can speak of a certain coming together of the two traditions, the naturalist and the positivist tradition. Okay, so I'll now try to be as concise as possible due to our time, which is running out. We should finish in 20 to 30 minutes. What is also important within this course, and in general, when it comes to studying human rights, is to understand different categories, classifications or taxonomies of human rights. Now, I will not speak of all of them. I will just draw your attention to these two groups, which will be most important for our analysis and our work throughout this course. And that is distinction between absolute and relative rights. Right to life, prohibition of torture, prohibition of slavery, enforced labor, no punishment without law, right not to be tried or punished twice, or for example, forum internum of freedom of thought, conscience, and religion are considered as absolute rights. So what it means, absolute rights, is that these rights cannot be restricted. These rights cannot be restricted. Yeah? Compare it to the third category here. The second category is somewhere in between. I will not go into details about it right now. Let's look at the third category, right to respect for private and family life. freedom of thought, conscience, and religion, freedom of expression, freedom of assembly and association. So these rights are also human rights, but they're considered as relative rights. Why? Because they may come into conflict with other rights. For example, media's freedom of expression, freedom to publish information about certain people, can come into conflict with the right to privacy of those people. And in that conflict, we have to have particular tools for resolving it, for resolving that conflict. So we have standards for deciding in these kind of situations whether the freedom of expression will prevail or the right to privacy will prevail. Or freedom of assembly, for example, freedom to manifest in the streets, to demonstrate, to express one's political views is definitely something which is recognized as a human right, freedom of assembly. But at the same time, that freedom can come into conflict with the public order and with the rights of other people. So we need to have tools to balance and decide who has right in that concrete case. Or, as we will see, a case which is directly of relevance to the gender equality issue, for example, wearing of Islamic veils. On one side, you can say it's a freedom of thought, conscience, and religion, because for some women, it is considered as, for women of some religions, it is considered as mandatory. Or at least these women consider it to be mandatory for them. But on the other side, wearing of veils, and especially wearing of burqas and niqabs, so not just that hair is covered, so you cannot see fully, sometimes you cannot decide fully on the identity of that person because half of the head is covered through the Islamic veil and hijab. But if you take into account burqa or niqab, where the whole face is covered, or sometimes there is just an opening for the eyes, you cannot at all say anything about the identity of that person. You cannot even be sure that it is a woman and not a man. So in that context, freedom of thought, conscience, and religion may come into conflict with a need for public order and security and safety. Yeah. So this is why we speak on the side of the relative rights and on the other side of the absolute rights. Yeah. So absolute rights. There is no nowadays in Europe, when since the death penalty has been abolished, there is no legitimate reason to take away someone's life, or there is no under any conditions there is no justification to apply torture on someone, inhuman or degrading treatment, or to take someone, to place someone into slavery, to take someone as a forced labor, etc., etc. So these are the absolute rights cannot be limited, infringed. Relative human rights are very, very high in the legal system. As we said, they're superior to all other rights, but since they may come into conflict with each other, we have to have a test for balancing between them. And this is what we will do. We will, especially with me, we will study these tests, and of course with Professor Ivana Krstic, who will have the next class with you within this course, human rights and gender equality. We will be talking to you about prohibition of discrimination. Justified, and this is exactly what we're going to be talking in this course in the context of gender equality, because gender equality presupposes what Catherine McKinnon said, taking social reality into account. So it presupposes that in order to redress the disadvantage which has been historically, which has been in which women have been living historically for many centuries and millennia, that in order to redress those disadvantages, we need to set up some special rights, and we call these temporary measures that we may introduce to improve the position of women or other groups which are disadvantaged, such as racial groups, such as ethnic groups, such as religious groups, such as transgender groups, as affirmative actions. And sometimes they are called positive discrimination in contrast to the negative discrimination, but generally the term affirmative action is more favored than the positive discrimination. So we speak of the affirmative action when there is a need to recognize rights for the particular groups. We come back to the gender equality. From women's rights to gender equality, we want to actually show that even the term women's rights is not the best, the preferred, because one may imply under the term women's rights that women enjoy maybe more rights than men. Whereas the term gender equality implies that we should all be equal now, forever. And this is a distinction which we make also between affirmative action and collective rights, such as the rights for ethnic groups or racial groups. We consider that affirmative actions should be put in place as long as it is needed to bring these groups in the position of equality with everyone else. So if we speak of women, then to bring them in equality to men. If we speak of transgender people, to bring them in equality with cisgender people, etc., etc. And we want to have equality not on the paper, the formal equality. We want to have equality of opportunities and equality of results. So we have to see, we want to see equality in the opportunities already and in the results, not just in the formal sense. So we spoke of the controversy about human rights that some people, even some intellectuals consider that human rights is a controversial concept in itself, it is politically manipulable, and that it should be actually even abandoned. Well, you can imagine that the concept of human rights and of gender equality is even more manipulable, or some people consider them to be even more manipulable, and in that sense that they are even more controversial. So taken into account, and it is exactly for this reason that we are having this course, in order to define as much as it is possible what we mean by gender equality in the context of human rights, so that we leave no place for any kind of manipulation or for any kind of misunderstandings and misinterpretation. The controversy about women's rights or gender equality is all the more stressed due to the fact, but just give me 1 minute, I have to ask a porter something and I'm coming back, I'm sorry. Okay, so you have had a course on feminist legal and political theories, and you have had the opportunity to learn about different strands of feminism. So liberal feminism and radical feminism or structural feminism is not the same thing. And feminists, whether they are liberal or radical, ask for different things. And they understand gender equality in different ways. So already there is a source of, so to say, place for controversy. And this is why we need to take a good look at what gender equality in the context of human rights implies. Here I just give you a very short reference to these possible divergences in approaches. For example, liberal feminists, they favor the gender neutral approach. They would like to actually have, they would like for women to have the same rights as men. They, after a long period of non-recognition of rights for women, they, in the next stage of the development of human rights, so there we speak of the second half of the 19th century, beginning of the 20th century, and then as a result, the recognition of political rights for women in the, in the third decade, in the 20s of the 20th century, and then especially after the Second World War, the recognition of political rights for women. They also asked for equal, not just political rights, but other rights relating to business sphere, relating to family law, equal wages, equal condition of working, equal condition of retirement, etc. So they have a neutral approach to gender equality. But for example, radical feminists, they demand a differential approach. They consider that whereas before differences were reason for disadvantaging women, now the differences should be a reason for advantaging women, for providing them with more rights so that they could reach this equality of opportunities and equality of results. So that in reality, as Catherine McKinnon would put it, there is a social, that women are recognized as human beings in social reality. So this is a gender differential approach. And then when it comes to gender equality, we may see that the problem may be exactly with actually these binaries of female and male. That actually there may be, as it was the case with the German Federal Constitutional Court, a need to recognize a third sex. Because there are people where it is, when it comes to pure sex, it is not possible to establish whether they are male or female, intersex. And so the German Federal Constitutional Court recognized that there is a intersex, there is a third sex. And this implies that, Myla could tell us maybe that normally in the administrative documents, there should be a possibility. I mean, I don't know if you have noticed it, a possibility as a result of the ruling of the German Federal Constitutional Court, a possibility to declare oneself, not just as it was in one point of the development of the German legislation a possibility to say neither male nor female, which is already something. Because people who do not consider themselves male or female were historically, where it was possible, forced to undertake surgery in order to conform themselves with a male or a female type of sex. Whereas nowadays there is that kind of expansion of understanding of the rights, that they should be allowed to choose whether they want to have a surgery or not, or whether they want to stay as they are. And so at one point they said, even this neither is not correct, because what about our human dignity? Why, if there is male and female, why should we consider as neither? We can be considered as citizens, full rights, full-fledged citizens, if there is a human dignity and we respect the human dignity, and we should have a right to have our own category. And this is just one problem of the binaries, let alone the problem of, and not the problem, but the issue and the question of transgender people who are not sure about their gender identity, or where their gender identity does not overlap with what their sexual identity would imply. So there is that kind of discrepancy between gender identity and sexual identity, and there is obviously a need for the further recognition of human rights and human dignity of those persons, and hence the problem of binaries in the context of gender equality. And we here mostly speak of women's rights, but actually the range of those people with who claim for gender equality is much wider. So we need actually we come to the understanding that we need to have in this context a reconfiguration of institutions in order to address these issues. And we will throughout this course, we will be exactly talking about these questions, these issues. Now, just briefly, I will say that we will be talking about discrimination and gender equality in the context of prohibition of violence, prohibition of right to life, and prohibition of torture, but also in the context of rights of migrants, where women and asylum seekers and refugees, where women are particularly affected, or the case of a prohibition of slavery and forced labor, where also a prohibition which behind which there is a right not to be put into this position, a right which particularly is important for women because they are those who are suffering the most from this kind of violation of these prohibitions and these rights. And we will be talking of other civil and political rights. So we'll be talking about women's rights in the context, not just women's rights, but gender equality in the context of right to privacy, of freedom of thought, conscience, and religion, in the context of recognition of political rights, gender quotas, restriction of freedom of expression in the context of prohibition of sexist language and other forms of verbal violence. Okay, so this is just in a nutshell. You will see that there is much more in this presentation, which I will share with you. So you will be able to have more information about taking gender equality seriously in human rights law. And now I open the floor once again for your potential questions or comments. Anastasia? Well, we will be talking about it within the context of this course, about this conflict of this aspect of the right to express one's religion through wearing clothes, because this is a way of expression of one's religion. There are different ways of expressing one's religion, and maybe rituals, it may be dietary regimes, it may be teaching as well as a way of expressing one's religion. But there is also this way, by wearing clothes, like Jewish kippas, like Sikhs, they have turbans. And in Islam, women, they under some understandings of Islam, so it's not a universally accepted reading of Quran, but under most of the readings and understandings, women are expected to wear hijab, and according to some readings, they're actually a headscarf. But under some understandings of Quran, they're even expected to cover their face fully, or just to leave one mesh open for the eyes. We will be having a particular lecture on this, and you will have also some assignments about it, because there is very interesting case law in the practice of the European Court of Human Rights. For example, about whether public agents, women who are public agents, can wear headscarves or not. Whether they, especially if they are teachers, but also about students, and about girls of younger age than students, in high schools and elementary schools, whether they can wear headscarves, or about wearing of headscarves at other workplaces, not schools, but if you're a public agent working in another public institution, whether you can wear it. And also whether you can wear, for example, as it was the case in SAS versus France, whether you can wear burqa or niqab in the street. So there is that issue, whether you can wear, whether you can show up just like that in France completely. That case came about, and it was judged. That case was also before the European Court of Human Rights. There is also a case of whether French Association, French Football Federation, can forbid to women who play football wearing hijab, under the pretext that religious symbols in the football pitch can be a reason for public disorder, for example. So there is a very interesting then issue of potential discrimination between religions, because we see that this norm prohibiting wearing of, it doesn't say that no legal system in Europe prohibits wearing of hijab or burqa as such. They would say that it is not possible to cover your face or cover parts of your head in the given circumstances. So this is what we call indirect discrimination. It's not a direct discrimination because it is not targeting directly Islamic religion, but it is indirectly actually targeting Islamic religion. So there may be a conflict of, there may be a question whether there is respect of the right to religion in these countries, whether there is a discrimination between Islamic religion and other religions. And also we can ask ourselves if there is that kind of ban, which we know that affect women more than men, is that kind of also indirect discrimination of women? Because no man would suffer from that kind of, except for example, members of the Jewish religion who consider they have to wear kippah, or Sikhs who consider they have to wear their turbans. But we see that it substantially affects Islamic women more than anyone else. So we can ask ourselves whether there is a case of indirect discrimination. So it's a very interesting topic, and there are quite a few of interesting cases that I can share with you, but when the time comes. Okay. Any more questions or comments?
Dear Professor,
Yes, thank you to you too. Good night. I know that in Bangladesh it's already. What time is it now? Right now in Bangladesh?
It's at 2 p.m. It's
2 a.m.
5 hour.
Okay.
5 hour plus
Okay.
with you.
Sleep well.
Hello, Professor, do you hear me?
Yes.
I'm so sorry tonight. My internet had problems and I could not upload the video. I hope you will not hold it again. And I hope to see you in the next lecture video.
Okay. I also hope to see you too. And I hope you will have a better internet connection already tomorrow.
Thank you so much.
You're welcome. Okay, I thank you all. I'm sorry that we started today's course at 7 and not at 6, and all the more that we even started later than that. But we luckily managed to catch up and to say most of the things that we were supposed to say. Okay, thank you for today, and see you already tomorrow at 6.
See you tomorrow, Professor.
And online.
Thank you. See you.
You're welcome. Bye-bye.
Bye-bye.
Vidimasa Sutra.
Vidimasa Sutra, yes.
Sutra.
Bravo.